And good evening. Welcome to City Focus. I'm Marty Olsen, your host, and tonight I'd like to welcome back a longtime good friend, Carl Schuman, the Honorable Carl Schuman.
Please call me Carl, Marty. We're old friends, maybe 65 years
That's amazing.
going back.
Well, I think what's even more amazing is that after 65 years, we maintain a very viable friendship, and we get together from time to time, and have been doing it for years.
Usually to watch sporting events together.
Well, it's a common interest.
It is. We may not root for the same team, but we enjoy watching.
Well, yeah, we don't root for the same politics, we don't root for the same teams, but we get along.
That's what we should be doing.
And I think we're a good example for those out and about.
I
That
agree.
we can have civil discourse and have some fun at the same time.
I agree entirely.
So I want to again thank you for coming down from West Hartford to be
Sure.
on the program, and you had prepared some topics for consideration, which I looked over, and I would like to delve into them. One of them is one I think that all students in Connecticut ought to be getting at some level, whether it's a high school civics class or junior high. But why is Connecticut the Constitution state?
And why do we have it on our license plate?
I mean, we were growing up, we were called the Nutmeg State.
Well, it's not anything new. And as a matter of fact, the reason I mentioned that topic was that yesterday was Constitution Day. I don't know if you realized it. You don't get a day off from work or school because of it. But in September of 1787, the majority of delegates at the U.S. Constitutional Convention in Philadelphia voted in favor of the Constitution. Then it was sent to the states to ratify. But Connecticut is called the Constitution State, not because of anything having to do with the federal Constitution, and actually nothing to do with the state Constitution. The reason Connecticut is called the Constitution State is because the first written document that resembled a Constitution was signed in Connecticut. It's called I'm sure you remember this from Harbor School.
Well, wasn't this where they stuck the document in a tree or
Well,
something?
that was the second one. That was the charter from England. But I'm sure you remember from Harbor School the Fundamental Orders of Connecticut in 1639.
Yep.
And that was an agreement among the Hartford, Windsor, and Wethersfield, three of the oldest towns in Connecticut, to form a type of representative government and also to confer some limited rights on the people of those communities. Now, by modern standards, it wasn't a very representative government. It was only people who, white males of sufficient property, who were entitled to vote. But nonetheless, it was the first time that people had written down their plan for government in a charter and conferred some civil rights on people. And so, because that happened in Connecticut, we call Connecticut the Constitution State. I'll just add that it's not because of our state constitution. Our state constitution was not approved until 1818, well after the founding of our nation and well after many other states like Virginia and Massachusetts had agreed upon a state constitution. We were rather late in that game, but we were early the first with regard to something resembling a constitution.
Well, now, Virginia and Mass are both commonwealths, correct?
Very good trivia point.
I mean, so does that have a difference in terms of how the government functions?
No, it doesn't. And I'll ask you a question. Can you name the other two commonwealths in the United States?
Well, Kentucky is one.
It is.
And
The
I
other
sure
is
know the other one.
It's a battleground state. We won't get too much into politics, but it's probably the battleground state
that
this
would
year.
be Pennsylvania.
Correct. Good harbor school education there.
Keystone State.
But it's really just a name. There's no difference in the form of government. So,
Well, that's interesting. I mean, I'm just wondering. I mean, I don't get the feel that today's youngsters are getting the level of history and social studies that maybe we had coming through. And you're in the classroom now too.
I am.
So, although I think you're dealing more in a law school level.
Yes, I teach some courses at Quinnipiac Law School and last semester at UConn Law School. I've volunteered a little in high schools in Hartford as well. We're old enough so that we remember things from way back in our childhood, and facts like that we tend to remember. But I'm not an educational expert, so I can't comment on the quality of education these days.
Well, there's an interesting thing, I think, to kick things off with the Constitution state. But I want to deviate just a skosh here.
Okay.
We were talking before we came on the air just about reading, because I brought a couple of books out.
Good for you.
I've got a stack at home, and I kind of try to make my way through them. And this is what I'm currently reading by Jonathan Turley here, and this is all about free speech. And it's been a fascinating read. And it goes back kind of to the beginning, to the Greeks, and our Constitution and the Bill of Rights is the real first formal written document outlining freedom of speech. I mean, the sedition, I guess, was rather prevalent forever, and it was challenging authority was frowned upon.
Well, your comment makes me think this. Connecticut is called the Constitution state. We could call the United States the Constitution country, because we're really the first country to have a written constitution, and then followed that it eventually included a Bill of Rights that recognized in writing expressly and enumerated these rights like freedom of speech and freedom of religion. And I think that's something to be proud of.
Absolutely. One of the things that I found interesting in this read is that how, although it's written into our Constitution, I mean, almost immediately, starting with the Adams administration, with the Alien and Sedition Act.
Not a highlight of our
Let's
U.S.
blow
history.
it up. I mean,
Yeah.
and almost it seems, at least according to Turley, excuse me. Hurley's our basketball coach.
Right.
We were
Easily,
talking about that too earlier.
That name flows off the lips as well.
Is that when those get into power, left or right, they all like to feel protected from the masses, and and that battle has been bobbing and weaving since the beginning as well. And you're in a position on the bench where. I suspect, you've got to deal with some of these things and interpretations of Supreme Courts and opinions and precedents and all sorts of stuff.
Yeah, and really a court is a venue or kind of a home for free speech in a way, because we hear both sides of every story, and there usually are at least two sides to each story. And each side has a right to express his or her or their views. And so that's how sometimes you find out what the truth is, by hearing both sides. Thomas Jefferson, one of our founding fathers, said that dissent leads to inquiry, and inquiry leads to truth. So he embraced the notion of dissent and free speech to advance the goal of truth, and that's what we try to do in courts as well.
Like I say, it's been interesting to read. Something that I think that you would enjoy reading, and you are a reader as well.
I try.
And give us a chance to, at another time, we can sit down and discuss this specific book.
Well, like you, Marty, I have a tall stack of books I'm trying to get through, so it may be a little while.
I have a feeling you get through them more quickly than I do. But the next on the list is The Making of a Leader, The Formative Years of George Marshall, and the Marshall Plan, and how that has, I think, so positively impacted, global relations post World War II. I mean, World War I rolled into World War II rather quickly, with folks feeling they'd been taking a beating after World War I, and flamed the passions of nationalism in Germany, which in turn helped to fuel World War II.
Sure. Well, that sounds like another interesting read. Certainly, if you're going to write about a leader, you might want to write about George C. Marshall.
So I'm looking forward to that one as well.
Good for you.
Now, you jotted down criteria for jury service. And now, is that changing?
Yes.
And if it is, how and why?
Yeah. Let me tell you.
Is it just Connecticut, or is it something happening all over the United States?
There may be similar moves in other states. I can't say for sure. I can talk about Connecticut. But I think what Connecticut has done is kind of consistent with what may be a trend elsewhere. And so we have done several things by legislation, the General Assembly, to expand the pool of eligible jurors. So, for example, now not only citizens but lawful permanent residents of the United States.
So green card holders?
Green card holders. These are lawfully admitted and residing in the United States on a path to citizenship. They are eligible for jury service. Second, now we have reduced the time after which a convicted felon becomes eligible for jury service. So now we've reduced, now a convicted felon, after he or she has completed his sentence, need only wait 3 years before becoming eligible for jury service. It used to be 7. I think this is consistent with our philosophy that it shouldn't necessarily be a permanent punishment if a person has rehabilitated. Now finally, the one that you might be most interested in, and I as well because we're the same age,
Yes.
is that jurors are now eligible up to age 75 to serve. And after 75, it's voluntary. If you don't want to serve, you don't have to. But your name could be called. I know your age because it's the same as mine.
Well, you've got me by, I think,
a month?
2 months. So you're at the beginning of January.
No, end of January.
And then it's a month.
So it's only a month. Yeah. Don't age me. But we are both, although I'm statutorily not eligible because I'm a judge, but putting that aside, still eligible for jury service for the next 5 years. And I want to say that although I haven't had that much experience with convicted felons, we don't see too many of those. But as for permanent lawful residents and as for older jurors, I think it's a good change. The people I've met in those categories are very eager to serve, particularly the older generation has the time, they have the life experience, and they make good jurors.
Yeah. I've been called 2 or 3 times,
Good.
but gone, but then not been called.
Yes.
I'm not sure what the proper terminology is.
Yeah,
but,
excused or dismissed.
I mean, the case was settled or whatever, but in any event, I was not called in to be a juror. It was in the pool.
Right. Did you ever get to the courthouse? Or?
Sitting in the courthouse,
Oh,
yes.
okay. All right. Yes. So a lot of cases, civil cases, we say settle on the courthouse steps. On the day of trial, the lawyers find a way to compromise or settle their case. Even criminal cases, although different factors involved here, but criminal cases can occasionally plead out by way of a plea agreement on the day of trial. So you get called in, and because you're there, that's an incentive to the lawyers to try to work things out. So you're just by being there, you have served an important purpose.
Yeah. I mean, I would love to serve on a trial. I mean, that, to me, I think would be fascinating.
I think you'd be a good juror, Marty.
Well, thank you. But, you know, it baffles me that so many people look for reasons to not.
Yeah.
I mean, they'll, feign breaking a leg, anything to not do that. To me, it's just, it's part of our civic duty.
Yes, it is. But I find that only about 10 to 20% of the jury pool has that attitude. But I will add this, that I talk to the jurors when they come in the morning. We have a greeting at the jury assembly room. And I usually say this, that you seem a little bit sleepy. Many of you don't seem like you're all that interested, but I have spoken to now over 1,000 jurors after they have served, heard a case, and rendered a verdict. And almost without exception, regardless of how they felt at the beginning, they were glad they had served at the outset, at the end, because they made a decision that was very important to the parties. They learned about a subject that they didn't know about before, whether it's medicine or auto accidents or crime investigation, and they bonded with their fellow jurors. So they, at the end of the process, really appreciated and enjoyed the experience.
Now, if during my on and off tenure as an elected official, would I be eligible to serve during those times, or if I was to ever be elected again to any office?
Yeah, I'm going to just take a quick look at the statute, which I brought here, see if I can. I think you would be eligible. The ineligible officials are state officials. So if you do get elected for governor, you would not be eligible to serve. But I don't.
State rep, state senator.
Yeah, I know you've done that as well. And it just says governor, lieutenant governor, secretary of the state, treasurer, comptroller, or attorney general. So I think that
those are statewide offices.
They are, yeah. Looking quickly, I don't see an exception for state representatives or senators, but this is how things work as a practical matter. If you have a good reason why you can't be there for jury service, we let you go. If you're a state rep and the legislature is in session, we're going to let you go. We're not going to interfere with the legislative process, a co-equal branch of government. If it's summer and you're not in session, then I don't think it's an automatic disqualification.
Mm-hmm. Again, I find it very, very interesting. And now, is there you mentioned the age at the high end.
Right.
Now, do you have to be 18 to
Yes.
to serve? You can't be under 18.
No, you can't. 18, I believe, is the age.
Do you find young people anxious to serve, or are they...
Generally, no. But they have a lot of things going on in their lives: school, college, moving, trying to get a job. Maybe they've just started a job. They don't want to offend their employer, even though employer cannot take any action against them for jury service, but they don't want to ruffle any feathers. So also, I will say this: the lawyers generally don't want young people. They want people with life experience. Have you had to pay a mortgage? Have you driven a car and owned a car? Do you have family, work experience? So we don't have too many young people on the jury, although I have seen some.
Yeah. Is it more difficult to secure jurors in higher profile cases where whoever's, the litigants or whatever are well known, whether it be in the community or the state, whether they're, like this musician who just got arrested a day or two ago.
Right.
And the charges, at least on the surface, seem rather serious. How do you, although I don't know much about them, so I guess if they put me in the jury pool, I could be fair and balanced because I don't know you, pal. The young people may, but you're not in my social circles.
Right. Well, you mentioned a couple problems in high-profile cases. One is the likelihood that you know the person involved, whether it's the president or a music star. People have formed opinions, and it's difficult for people to put those aside and keep an open mind. Or they may know the lawyers or some of the witnesses involved in the case, if it's a high-profile case. But another problem, and this, even though you don't know this musician who was just arrested, another problem might be high-profile cases tend to take longer and take you away from work or school or family or whatever else you have going on in life. So it might not be convenient for you to sit. And then, depending on the crime, if it's a gruesome murder, multiple victims, or allegations of sexual assault. I know there are allegations of that sort, sexual trafficking in this recent case. Some people understandably just don't have the stomach to sit on a case like that. So it is more difficult to get jurors in that sort of high-profile case. As a result, we just call more jurors in for jury selection on day one.
Now, how often, maybe that's not the proper way to phrase the question, but how challenging is it? You want defendants to get a fair trial.
Yes.
Where a trial is held, I mean, if a crime is committed here,
Right.
but everybody here knows all the players, how are you going to get a jury pool that doesn't either know everybody or you have a predisposed opinion to the case?
Yes, so that's certainly an issue. But you'd be surprised, Marty, how little attention people pay to the news. I hope they're watching this show. But jurors are commonly asked, do you pay attention to the news? And a common answer is, no, it's too depressing. I don't watch it. Other people say, yes, what's your source of news? Social media, which may or may not be the most reliable source. So there is a certain percentage of people who may not be following this high-profile case, whatever it is. On the other hand, the defendant has a right to have the case tried in the jurisdiction or district where the crime was allegedly committed. So we have to try to preserve that right and at the same time get people who have not formed an opinion on the case. It can be tough. It's a little tougher in highly publicized cases, but it is possible.
Now,
I'll just add this. I'm
sure,
sorry to
please
interrupt,
do.
but you may have heard about this case in Idaho with a person accused of murdering 4 University of Idaho students.
Yeah, that was
in
in the last couple of years.
Well, you may or may not know that the judge recently changed the venue from Moscow, Idaho, that's Idaho, not Russia,
Yep.
in kind of western Idaho near the Washington state border, to Boise in the central part of the state, because the judge concluded that it's a small community and so many people were familiar with the case and had formed opinions that it rose to that level that the venue had to be changed. So if all else fails, the venue can be changed, but we try not to, because the defendant does have a right to have it tried in the community.
And whose decision is it to move it? Is it the judge's?
Yes. And that can be reviewed by an appellate court, but in the first instance, that's the type of decision that we trial judges make.
And is that something that you would initiate, or would the lawyers ask for that?
The lawyers would ask for it. And it's, quite honestly, it's frequently the defendant, even though he has that right to have it tried in his own community, who asks for the change because he's concerned, or she, that people have formed opinions and in fact have formed negative opinions, just by the way news works. Person's arrested, people make assumptions. The news is rarely good when a criminal case is followed from step to step in the media. So it's usually the defendant and his attorney who asks for it.
Now, what about cases where you've got defendants that are gangsters, mafia, gangs, whether it be jurors or witnesses that may feel afraid for their person that by participating in this process, that they'll get harmed.
Right.
And is there protection for them? I mean, that could be a rather frightening environment.
Yes, it's a good question, and that's a real concern we have in a city court like Hartford, where there's a concern about retaliation and intimidation. So for witnesses, there ultimately is a witness protection program as an ultimate remedy. But it does at times get difficult to get witnesses to come to court. For jurors, if jurors express a sincere and serious concern about their safety sitting on a particular case, we will generally let them go. We usually find a certain percentage of the jury pool that's willing to serve, even though it's a little uncomfortable, because they know it's important to the parties and to the state. Ultimately, in some cases, hasn't happened too much in Connecticut, but ultimately we can keep jurors' names anonymous, so that although the record might be sealed and there might be a way for participants in the case to find out the name, the public and witnesses can't find out the name. And we're looking into ways to do that a little more because of jurors who have expressed these concerns.
Well, I think it's legitimate. I mean, not that law and order is the end all for the legal system,
Right.
but for many folks, I'd say probably millions of folks, it's their look into the criminal justice system, or Perry Mason before that.
Well, I stopped watching TV shows about the law because they're so inaccurate, but they may be good entertainment.
Well, I suspect they are. I mean, my grandfather thought Perry Mason was real.
Things don't work that way.
Well, I understand that,
Yeah.
Carl, but TV was new in those days too.
Yeah. Right. So it was all new and novel.
And it's amazing he solved all his cases in an hour.
Yeah, things I'm afraid go a little bit slower than that in real court.
Speaking of that, now that we're post-COVID, has the system caught up, or are we still lagging well behind?
I would say we're just about caught up. It took a while, and particularly for some criminal cases where defendants were in jail in lieu of bail pending trial, there was a long, unfortunate wait. But now we're hopefully 3 years post-COVID, and I would say in Hartford and elsewhere, from what I know, we are caught up. Civilly, on the civil side, we did try to do a lot by remote transmission by Teams or Zoom type technology, and although we didn't try jury cases that way, we did try to move the cases along. On the criminal side, it's a little more difficult because the defendant has a constitutional right to be in court.
Okay. Now, are you still working full-time?
Truth be told, I'm not working full-time as a judge because I've reached age 70. Although I can ironically serve as a juror, I can't serve full-time as a judge. Our state constitution, which was enacted in 1818, had a provision saying that judges are no longer entitled to serve full-time after age 70. So
what are the limitations
Yeah, so we, with some exceptions, we can't try jury cases, despite our conversation.
Yep.
There are some jury cases we can try. We can try what we call bench trials, or trials where the judge is the fact finder, decider. So I am going into court on the average 3 days a week, and I'm teaching at Quinnipiac University School of Law 2 nights a week. So
You're working full time.
I'm actually working more that I'm retired than I was before.
You enjoy being in the classroom?
I love being in the classroom because I like young, fresh, eager minds who really want to learn about the law. And I have a lifetime of experience. I try to share some do's and don'ts with them. Some law school teachers and professors have not actually been in a courtroom or been in the practice of law.
They're academics?
They're academics, you could say. I sense a slight negative.
Not necessarily.
No, but okay, so they shouldn't be, but it's a different experience just reading cases and writing about them than actually being in court and doing them. And that's the experience I try to share with my students. I really like it.
Now, I'm going to just take a little bit of from here, because there's a chapter on higher education,
Okay.
and Turley expresses concern that the higher ed is shutting people down and discouraging a free flow of discussion and ideas. It's kind of like, if you're on the wrong side of an issue, you just better not participate, because we're going to kind of cancel you out,
Yeah.
whether it be in the classroom or beyond. And are you seeing that type of activity, whether it be what you're doing at Quinnipiac or in the courts themselves, news media? I mean, it's kind of a broad question. But I think there's a concern there.
Yes, I share that concern. I'm not seeing it in the courtroom or either at Quinnipiac or UConn, but I read the papers like you do, and I certainly saw things last winter and spring that concerned me, and I think that there is somewhat of a culture of political correctness on campus, and dissenting views are often frowned upon, which is so ironic, because a campus should be a citadel of free speech.
As it was designed to be.
Yes. So, although, again, I don't see this on a daily basis, I share your concern about that.
Yeah, I mean, it's just that exchange of ideas, and let good ideas rise on their own merits,
Right.
and bad ideas will fail. I mean, but the way you invigorate thought is by challenging things. It's not on a plateau.
No, that's the old John Stuart Mill.
Yes, he's cited in here frequently.
Is he really? Yeah, well, that's sort of utilitarian philosophy, and I think there's merit to it, and so we should listen. As a judge, that's one of our most important tasks, is just to listen rather than to talk, just to listen to other people. We have to realize that although we may jump to a preliminary leaning on a case, and that to the parties in court, it's the most important case that they have, and they want to have their day in court, and they're entitled to it. So, although at times it's tough to do, we have to listen a lot, and I think that's a good idea generally, is that people should listen to points of view, even if they disagree with it, and because again, what Jefferson said, that, and let me phrase it this way, that I think there's always something to be gained from listening to somebody you disagree with. You may still come away disagreeing with them, but there may be a little kernel of truth, or a shading of an idea you had that you
or
can't.
an area where you agree.
Yeah.
You don't just fully disagree. on both sides.
Right, right.
There is some common ground someplace.
Let's hope.
That's one of the things. Yeah, I took some law classes when I did undergraduate at Conn College, and it was I found fascinating. I'm not enough where I think I'd want to practice law, but it was interesting just to see how things evolved. A couple of constitutional law classes, and I took an
Good.
Indian law class with Tom Londrigan, and just interesting to read about this stuff. That's why I find this kind of a book interesting to keep the gray matter moving.
Good for you. Probably not a page turner, but
No, and there's some areas where it's not the easiest reading.
Yeah.
But it's certainly not. It's not a romance novel here. This is,
right. Good for you, Martin.
And I've got at home a book that Neil Gorsuch just had published, and I'm curious to see get his take on things.
You may learn a little about what we call textualism, which is an attempt to interpret the Constitution or statutes quite literally by the text, and sometimes leads to surprising results. So next year we can talk about that.
Okay. Well, I always enjoy our banter here.
Right.
So let's see what else we can move on to here. Let's see. We're talking. The Second Amendment's always a hot topic issue. You've got red flag laws for gun possession. Can you define that? What does that mean? And what does it hold? What does it? There's millions and millions and maybe more guns in America than there are people.
I've read there are, yes. But the U.S. Supreme Court, whether you agree or not, has held that the Second Amendment means that there's an individual right to bear arms, even though it's worded in perhaps the most confusing way with that prefatory phrase, a well-regulated militia being necessary to the security of the state. Sounds like they're talking about a militia. The militia can bear arms, but the court has interpreted it to confer an individual right to bear arms. The Connecticut Constitution, and we keep coming back to our Constitution.
That's where we live.
It is actually very clear, more clear in conferring a personal right to bear arms, because it says something to the effect, and I'm paraphrasing, the right of each citizen to bear arms shall not be infringed. So it's clear that in Connecticut there is an individual right to bear arms. On the other hand, the Connecticut Supreme Court has held that that right does not prohibit the legislature from banning assault weapons, because that's not what the right to bear arms was about. It was primarily for self-defense, and an assault weapon is not necessary for that. So we have an assault weapons ban in Connecticut. Now, let's get to the red flag laws and risk protection orders. Under what we used to call red flag law, now we call it a risk protection order. The state or local governments can come into court and first they actually go to a judge with an affidavit or testimony that a particular person is a risk to himself or herself or others, and get an order prohibiting them from possessing firearms. And if a judge signs that order, then we go into court in 14 days and have a hearing. If the judge confirms that order, this is what it means: that person has to turn over to the police any firearms that he may have, and his or her name goes on the NCIS, National Crime Information System registry, so that person cannot purchase a firearm from a licensed dealer. So
I mean, they couldn't skip to another state and
right,
and go into a gun store, or
presumably not if that gun store is licensed.
Yeah.
Now, if some of these cases, if they're a minor or if they're a convicted felon, they're not entitled to bear arms to begin with, so it might not be necessary. But the theory behind this is that although there is an individual right to bear arms in Connecticut, government has a legitimate concern in allowing some people to bear arms because they are dangerous to themselves or others. And so we now have these risk protection orders called red flag orders previously, and many other states do, in which we have a court proceeding as to whether the person is, at least for 6 months, is entitled to bear arms. And in some cases, if we know that they have firearms, we also sign a warrant as part of that order so that the police can seize their firearms and hold them for 6 months.
And after 6 months, they
Well, then they
them
have a
back?
right. Then they have a right to come into court and petition to get their firearms returned or to get their name removed from the prohibited list.
And who makes these decisions that can have them lose their weapons? Is that a judge? Or
Yes, it is. No, it is a judge rather than a jury. It's a court matter rather than a jury matter. And I'll just add that I think these laws represent a fair balance of the right to bear arms on the one hand and protection of society on the other. And so, to me, it would be a good idea, if I may, that other states adopt them to try to protect their citizens from a certain element of the population, whether they have mental health issues or they're just violent in nature, that really should not bear arms at all.
Well, it's hard to argue that point. I don't own any firearms, and I have no desire to, but I'm a strong advocate for our U.S. Constitution and the Bill of Rights. If I was in Congress, I would fight to support the Second Amendment. The thing that I find it's disconcerting is that for those who are pro-Second Amendment versus those that are not, is that there's such a distrust between both parties. Is to give this much means that you feel like you're ultimately giving up this much.
Right.
And I think both sides are afraid that that's what's going to happen, or is happening, and which blunts rational discussion at times.
Unfortunately, that's probably true. But you have the political experience that I don't, and so I'm not. I'm not here to comment on today's politics. So I'm going to stay away from it.
Well, I just it's just there are different topics that just it makes it very, very challenging. And there are times when our legislators are given what I would like to say, two bad choices when they've got to vote. I mean, no matter which way they go, it's a bad choice.
Probably so. I mean, we do see some of the difficulties in court when cases involve guns. There's a charge of criminal possession of a firearm, for example. We have to ask, or commonly ask, jurors about their views on gun possession, and would they be willing to enforce a criminal statute prohibiting gun possession if the state or the government proved it. Some people might not, and they would be excused. So I see some of these controversial issues like guns, not so much abortion, but that's controversial.
It's certainly a hot button topic.
Yes, or maybe some civil rights issues. I see them in court sometimes, particularly in jury selection.
I'm sure that you do. You've delved into the Supreme Court's recent immunity decision. What is your take on that?
Right. Well, let me try to explain it just
Sure.
in a summary fashion, because certainly not here to comment on current political events. But it is an important decision, and it's not a pending case, so I am allowed to comment on a little, but I'll try to just explain it.
Sure.
The background is that public officials like judges, prosecutors, governors do have, and so similarly presidents, do have a certain level of immunity from civil suits. And that's really important because there are a lot of people out there who air their grievances by filing lawsuits against public officials rather than trying to get things changed through the legislative process or executive action. And it's just a practical problem for public officials. I've been sued, my colleagues have been sued, even though we have immunity. The suits get dismissed, but if we didn't have that immunity, then we might have to go to trial.
The system still has to churn through and just dispense with what's transpired. It just doesn't just disappear.
No, the doors are not closed. You can file the lawsuit, but then it gets dismissed because of our civil immunity. Now, the issue in the case that came down this July in the U.S. Supreme Court involved criminal immunity. Is a president criminally immune from criminal prosecution for acts that occurred during his or perhaps her time in office? No question that a president is not immune for any acts that occur before he or she became president or after. The question is, how about during his presidency? And the Supreme Court rendered a very broad form of criminal immunity to presidents and said presidents are immune for their official acts, presumptively immune for acts kind of on the outer perimeter or outer edge of official acts, and not immune for unofficial acts. If a president, and this is purely hypothetical, went out and committed a crime against something related to a romantic involvement or something like that had nothing to do with his or her office, the president could be prosecuted for that. But for anything related to his official...
Based on history, that could have impacted a lot of presidents.
Well, fortunately, they didn't take it to that length.
Since you used that example.
Yeah. Now, it's kind of an interesting decision because criminal indictments don't happen with the frequency and predictability of civil lawsuits. Anybody can file a civil suit, but criminal indictments go through a screening process before they are handed down through a grand jury or some sort of review. And you can agree or disagree with criminal prosecutions against the president, but there is a fair amount of screening by a public official sworn to uphold the law before a criminal case is filed. So a lot of people question the need for criminal immunity. If a charge is filed after all this screening, should a president really be immune from it? And the Supreme Court held if it relates to his or her official duties, a president is immune. They also, as part of...
But a president can't be looking over their shoulder,
right,
and do their job. I mean,
actually,
this is the we like to think anyway. This is the most difficult job on the planet for an individual.
Right,
and it's kind of hard to do it that way.
And actually, the Supreme Court used a very similar phrase in their decision. So you kind of read their mind a bit. Now, there's one other element to this mix, and that's impeachment. Because Congress does have a remedy of impeachment even if a president cannot be criminally prosecuted. And the standards for impeachment are somewhat vague, high crime and misdemeanor.
I'd say very vague.
Yes, yeah. But the Supreme Court said that criminal prosecution is not dependent on whether or not there's impeachment. So they're kind of independent alternative remedies. So it's a major decision that really was written for the ages, not for any events that may or may not be occurring now.
Yeah, I mean, no president that has been impeached has been convicted.
Okay.
Andrew Johnson, I mean, one vote
was impeached, but not convicted by the Senate.
That's my point.
Yeah,
yes.
Understood.
And Clinton was not, or Trump. I mean, and I just worry that we're going to currently start seeing impeachment used as a political weapon by either party, and I don't think that necessarily serves a useful purpose.
Yeah, I just wanted to explain for your listeners that, but when you use the word convicted, you mean convicted by the Senate, which really means removed from office.
That's correct.
Yeah, rather than
I don't
criminally
mean convicted, thrown in jail. I'm saying removed from office.
True, that has never happened.
So, but I worry that we're moving on a slippery slope with this tool that's in the bag.
Well, maybe that's for another guest or for another book.
Well, that's one man's opinion.
Right. I just don't want to touch politics because that's not my specialty or my jurisdiction.
That's okay. I mean, listen, we there's plenty to chat about.
Yes.
And we're running out of time.
No, the time has flown.
Bail is in the news a lot, where folks are kind of. It appears to the lay person that folks are going in, they're arrested and spun right out through a revolving door, and they're back out in the streets and committing more crimes, and it just the system appears to be not working well.
Well, I can understand that frustration because it does happen from time to time, and a judge doesn't have a crystal ball and can't predict the future. We have to balance a number of concerns. We do want to protect the public, and particularly any victims of crime. On the other hand, defendants are presumed innocent until proven guilty, so we shouldn't hold them unnecessarily. So we have to balance those concerns. There are other factors involved. Should bail be based on a monetary amount? If that's the case, then wealthy defendants are going to be able to make bail and indigent ones are not. That's not fair either. So there are a lot of issues. It's a very complicated matter, and we're trying to balance a number of factors and produce the best result.
Well, it is a challenge. It certainly is. In our remaining couple of moments here, is there any particular, well, I'm getting a note here, it's time to wrap it up
Okay.
here. I'm going to just say that you'd like to quickly opine on here while we've got a moment on the air here.
No, I'm just in the spirit of Constitution Day, which was yesterday, and the fact that Connecticut is the Constitution state. I'm glad to hear that you're a student of the Constitution, and I think it's a wonderful document written in 1787 or so, at least passed then, that with a number of amendments, I think 26, has survived through the ages and continues to give us guidance.
Well,
in
I
our
think
affairs.
that's one of the beauties of the document, is that there are provisions to amend it.
They are, and that is
And
necessary.
they're not easy. And
No.
they're not supposed to be.
No, the process is difficult. We haven't had a new one in a long time. But I think the Founding Fathers realized that times change, and so should our rules. And that's built into the Constitution.
Very good. Well, Carl, I want to
Marty,
thank you.
It's a pleasure seeing you. Go New London High School Whalers.
Well,
we both root for that team.
That team we root for. They opened up with a loss this past Friday night to Hand High School, but head up to Wyndham to face the Whippets this Friday night.
Go Whalers.
All righty. Folks, good night. We'll see you again soon on City Focus. Good night.